My name is Nadia de Bie, and I'm the Nadia from PWC Belgium. But I'll introduce the hosts of today just in a minute. So also from our side, welcome and thank you, Glenn, for hosting this webinar on the impact of Brexit on your mobile workforce. So let me first maybe start introducing with the speakers of today. So that is myself. I am Nadia de Bie. I'm a senior manager within the employment law department of PWC Legal here in Belgium. I am focusing on everything which has to do with global mobility. And I will guide you through the social security implications of Brexit going forwards. I have with me my colleague Chris Haveneers, who is an immigration specialist of our employment law department in Belgium, and Nadia Idris, who is senior manager and immigration expert from our UK office. So from our part, again, welcome. What are we going to go through today? First of all, just a quick glance over where do we stand today? What is the timeline, but in a very general way, of Brexit? Continue on what the implications are on the social security of people who work cross-border between the UK and the EU. Then going to immigration, first on the Belgian side and then on the UK side, because that will be impacted largely because the UK will become a third country for the EU countries, and EU nationals will become third country nationals with respect to the UK going forwards. And then we will have some time to go through your questions and answers. So as Glenn said, please don't hesitate to put them in the chat, and we will pick them up at the end of the session. Okay, so where do we stand today? Just as a brief recap, the UK notified its withdrawal and triggered an Article 50 withdrawal procedure in March 2017, so more than 3 years ago. And in June 2019, the start of the negotiations on an orderly withdrawal started, and they dragged out until the 17th of October 2019, when the UK and the EU reached a political agreement on the conditions for the UK's departure from the EU, so the Brexit, and on a transition period that only will last until 31st of December this year. Now, that was a political agreement that was reached at that stage, and it took really until the very last day before the actual Brexit date of 31st of January this year. Just in the nick of time, the agreement was signed and ratified by both parties. So on the 31st of January, we had Brexit Day, with the start of a transition period and a withdrawal agreement that is in place, and contains a last section on what we will discuss today, the citizens part, making sure that there are some transition rules going forward. There was a possibility to extend that transition period, and parties had the possibility to agree to an extension before the 1st of July 2020. It should have been asked for, but no extension was asked for. And so we are still in a negotiating phase until the 31st of December 2020, or at least to say we will see with the next EU Council meeting whether actually an agreement will be reached. There have been several deadlines that they said, okay, there should be an agreement, because otherwise we have no time to do the ratifications. But still, this week a lot of negotiations are in progress, namely on a trade agreement going forward as of 1st of January 2021. As I said, the end of this year, and so 31st December 2020, there is an official end of the transition period as per the withdrawal agreement. And as of the 1st of January 2021, UK nationals become third country nationals for the EU and vice versa. And together with that, in the UK, there's a new immigration system that will come into force. And so it will be very important to know for your mobile workforce that works cross-border to know what will happen as of the 1st of January 2021. When we talk about people and global mobility, there's usually four aspects that are important, meaning personal income tax, labor law, immigration, and social security. Today, we will discuss mainly immigration and social security. Why is that? Because for personal income tax, there is a double tax treaty between the UK and Belgium that will still continue to apply. So there will be no huge impacts to a personal income tax situation of persons working cross-border. But there will be a large impact for immigration and social security. Also, labor law is at this moment already a very national matter, and so there will be some implications because some of our national matters are based on EU legislation, but the impact will be mainly on immigration and social security. Now, what does that mean for social security? At this moment, during the transition period, based on the withdrawal agreement, when a person works cross-border, to determine where a person is subject to social security, the reference rules of the EU Regulation 883/2004, which coordinates social security schemes throughout Europe, remain applicable, as well as its provisions on aggregation of periods and export of social security benefits. So, meaning business as usual until the end of December 2020. That also applies to the entitlement and access to social security benefits. They continue as is. Meaning, for example, that a person who reaches his pensionable age in November at the end of November this year, goes into retirement but has worked in different EU countries will get his pension from the different EU countries as he would have before any annunciation of Brexit. Also, a frontier worker in Belgium who is subject to UK social security, but at this moment, because of his place of residence in Belgium, has access to Belgian medical health care, continues to do so. So there is really no change in social security position until the end of December this year. What will happen post-transition period? So as of the 1st of January 2021, and there it is important to have a number of situations in the back of your head. In relation to past situations, what does that mean? Provisions of aggregation of periods and export of social security benefits remain applicable for build-up until the end of the transition period. So in my example of the person who will retire, say that that person will retire in 2022, well, that person will still be able to receive pension that he built up over the past years, so that he will not lose out any pension build-up until the end of the transition period. What does that mean for continued situations? Let's say a person is in a cross-border situation at this moment and will continue to do so after the 1st of January 2021. There in the withdrawal agreement is also a transition rule, a kind of grandfather rule, saying that the reference rules of the EU regulation as well as the export and aggregation of periods, will continue to apply for as long as that cross-border situation between the UK and the EU started before the 31st of December 2020, and it continues without interruption. What it means continuing without interruption, I will come back to in the next slide. In relation to new situations, there are three different scenarios. The first one is that there will be a multilateral treaty which will never be the same as the EU regulation that we have now, but will be inspired by it. There has been a draft issued by the HMRC, and there are discussions still going on that multilateral treaty. But if there is no trade agreement, there will also be no treaty, or that is the expectation at least, that there will be no treaty on social security. And if there is no multilateral treaty, we'll have to see for the relation between Belgium and the UK, whether there's a bilateral treaty also with the other EU countries. But at least for Belgium and the UK, we have a very, very old bilateral treaty dating back to the 1950s. But both parties have stated that that bilateral treaty will not come back into force, and that seems to be more of a political statement than it is based on legal grounds, because based on legal grounds, I think there are arguments to say that the bilateral treaty would still apply, but it has been confirmed that they will not apply the bilateral treaty, and so domestic rules will apply going forward. Now, I said for continued cross-border situation, and I think those are the ones you need to monitor really right now, is that they continue to benefit from the EU regulation for as long as that situation lasts. It's not to be confused with as long as the relevant situation remains unchanged, though. A continued situation just means that you are working in a cross-border situation whereby the UK and the EU are involved, but it can be different cross-border situations that can succeed in order for that continued application. So, for example, a person who is posted from Belgium to the UK at this moment, who is seconded based on Article 12, meaning that the person remains subject to Belgian social security, well, he will continue to do so for as long as that situation is the same. But say that that person switches from a Belgian contract to a UK contract, then he will cross over to UK social security, but still on the provisions of the regulations 883/2004. So even if it is a different employment situation, but it is still a cross-border situation, the EU regulation applies. And also a possible switch from self-employed status to employee or vice versa is a possibility to have a continued application. Again, just as long as there is any cross-border element that is in place between the UK and any of the EU countries. As long as it is without interruption. Interruption, there are some periods that are assimilated with employment, like sickness, annual holiday, and so on. And the European Commission has also issued a guidance note in which it states that some interruption should not be harmful. But when we talked to the Belgian authorities, they were really strict in this, and they see no legal argument for that to have some interruption allowed. So a person who would switch, for example, employment and have a week in between contracts, well, then it is an interruption, and that stops the application of the withdrawal agreement provisions. So it is really important to make sure that all your persons who are in a cross-border situation for this moment, whether it is based on a secondment, whether it's based on a simultaneous employment, so working in different EU member states and the UK, or working full-time in Belgium but for a UK company, that you have all proper documentation in order. And if there is an A1 proving where a person is subject to Social Security needs to be applied for, make sure that you have applied for that before the 31st of December. You can still apply for that retroactively, but then, of course, you will have to make sure that you can prove that the person was already in that situation before. They will not just take it for granted that because you ask it, the person was already in such a cross-border situation before the end of the transition period. I said that for new situations, and for new situations starting as of the 1st of January 2021, most probably domestic rules will apply. What does that mean? It means that in general that there can be possible conflicts of rule, negative or positive, meaning that a person can be subject to different social security systems at the same time or to none. And unless it is specifically foreseen in national legislation, there will also be no aggregation of periods. So if there are waiting times that you have to fulfill to have access to a certain benefit, say, for example, medical care in Belgium, and you need to have a waiting period to fulfill, and you have a period that you have fulfilled in the UK, that will not be taken into account anymore. There will also be no export of benefits. So, for example, currently unemployment, if you are unemployed in the UK and you want to look for a job in another EU country, you can do so with the export of your unemployment benefits. Well, that will be no longer possible unless a domestic legislation would specifically provide for that. As to the subjection of a person to a social security system, what does it mean for Belgium? In Belgium, our national legislation states that you're subject to Belgian social security if you work in Belgium for a Belgian employer. So if you're being assigned from a UK employer to Belgium, you can call for an Article 3 exemption. So that is possible for inbound assignments. Outbound assignments, we have a possibility for going to non-treaty countries to remain subject to Belgian social security for 2 times 6 months. Otherwise, you could look at a voluntary system of overseas social security. In the UK, there's also a possibility to have a 22 weeks remaining subject to UK social security for outbound assignments, and also this exemption for inbound assignments. Although the latter, it is not quite sure whether it's also applies to EU nationals. Currently, it says that it's not applicable for EU nationals, but that is, according to my UK colleagues, due to change going forward. So what does that mean? Key takeaways for Social Security. Make sure that you know where your people are, that you have the proper documentation for them in place, and that going forward you factor in the fact that domestic legislation will apply and that you may have to pay Social Security twice, or your your employees may not be covered, and also pay specific attention to benefits, so that people do not lose out when they have to work cross-border. That was it for Social Security. So I'll hand over now to Chris to go through the immigration impact on inbound Belgian situations. Chris, over to you.
Thank you, Nadia. So when we look at the immigration impact which the Brexit will cause, we can also make a clear distinction between the transition period until the end of this year and the post-transition period as from 1 January. Until the end of this year, still the free movement of persons and employees is applicable, meaning that UK nationals coming to work to Belgium or any other EU country can still do this without the need for a work authorization. The same is applicable to Belgian employees working or EU employees working in the UK. UK nationals who already have a valid residence permit in Belgium will retain their work and residence rights also after the transition period. For frontier workers, also referred to as cross-border workers, they can also still work during the transition period without any need for a work permit. As from 1 January, UK nationals and EU nationals will be treated as third country nationals, meaning that for any new arrivals after 1 January, they will need to check whether a work authorization or a work visa is required according to the domestic rules of the country where they will be working. For business travelers who typically only come to work overseas for a couple of days or a couple of weeks, the activities they will perform should be checked meticulously in order to see whether or not a work permit or a work visa would be required. For short stays, so meaning for short stays, so to admit the entry of UK nationals to the EU or Belgium, or the other way around, for Belgian nationals or EU nationals going to UK, there will be a reciprocal visa waiver, meaning that the passport will be sufficient to enter either EU or either UK. Now we will have a look what it means for UK nationals coming to Belgium. As we discussed, so the free movement for UK nationals still applies during the transition period. That means that UK nationals who are already registered in Belgium at the Belgian town hall where they reside and have the so-called E-card, or maybe even the E+ card if they reside already in Belgium for more than 5 years, they will in the near future be invited by the commune to apply for a new type of residence permit, the M card, as beneficiaries of the withdrawal agreement. This M card will make a distinction, so will be clear it's for the UK nationals in comparison with the EU nationals who continue to have an E card. For frontier workers, cross-border workers, they also still can continue to work during the transition period without any need for a work permit. There is a specific rule for frontier workers who work in Belgium with a Belgian employment agreement, as they will receive the N card. A royal decree still clarifying the practicalities about the M card and the N card still should be taken. After 1 January 2021, the UK nationals will be treated as third country nationals, meaning that in principle they need to obtain a specific work authorization. For employees, this means either the work permit or the single permit, and applications for this can already be submitted at the regional authorities as from 1 November. For self-employed persons, for instance, who want to set up their own business here in Belgium, there is a specific authorization which is called the professional card, which they need to obtain prior to the activities. Those applications can already be submitted in Belgium as from 1 October. On the next slides, we will see how the standard immigration process look like, which specific categories can apply for a permit, and for instance, which conditions this involve, such as a salary threshold. We will also see what or who is considered as a business traveler. And we have already indicated, so there will be a visa waiver for UK nationals who come to Belgium for short stays. This means they do not exceed a number of 90 days within periods of 180 days. They will be able to come to Belgium just on the basis of the passport. Now we will concentrate on the post-transition period. So as from 1 January, what does it mean for cross-border workers? So we already indicated that persons who are working in Belgium with a Belgian employment agreement, they will be able to obtain the N card, and the N card holders, they will continue to be exempted from a work permit after 1 January 2021. If it's a cross-border worker who is seconded to Belgium by the UK employer, or who will work with a Belgian employment agreement, then a work permit will be required. There will be two possibilities. Either the person needs to apply for a work permit as a cross-border worker, or if it concerns short-term projects limited up to 90 days, then there's also the possibility to apply for such work permit. Special attention needs to be given to the business trips. Business trips, you always need to look at the activities which the person will perform. If it's, for instance, concluding a commercial agreement or gathering facts or one-to-one HR conversations, then those type of activities are work permit free, are work permit exempted, but they may not exceed 60 calendar days per year, with also per business trip, it may not exceed 20 days consecutively. What happens if an employee will work and reside in Belgium for more than 90 days? Then we need to follow the so-called single permit procedure, which has its own conditions and its own set of required documents. As a general principle, there is the labor market check, which means that in principle, for a certain function to do in Belgium or a certain job to do, there should be a shortage on the Belgian and EU labor market. Each region, so the Brussels region, the Flemish region, and the Walloon region in Belgium, have, however, determined several privileged categories. Those privileged categories do not need to comply with this labor market check. Since 2 decades, and it will also continue in the future, the most frequently used categories are the categories for the highly qualified employees and the managerial employees. As a highly qualified employee is considered a person who is at least in possession of a bachelor or a master degree and earns a gross annual salary of at least 43,500 euro. Managerial employees should earn at least a gross yearly salary of at least 72,400 euro. Please do note that each region has, however, its own salary thresholds, and you should check where the person will work in Belgium to determine which minimum gross salary is applicable. When we look at the procedure for a single permit application, there is, as a matter of fact, there's a three stages procedure. First, a single permit application needs to be submitted at regional immigration authorities of where the person will work, so either the Brussels region, the Walloon region, or the Flemish region. And typically now, the average processing time for that approval takes 8 weeks. So it's and the region and also the immigration office which take an approval decision. So the approval decision to work and reside in Belgium. Once the applicant has both approvals, he can apply for the Visa D at the Belgian embassy. The Visa D will then be put in the passport of the person. That process takes in general not more than 1 week. And after the single permit approvals are obtained and the Visa D is obtained and the person arrives in Belgium, it is in general accepted that the start of the working activities are allowed. Once the UK employee will arrive in Belgium, he or she should still register at the Belgian Town Hall. And it's at the Belgian Town Hall where the person in the end will obtain the single permit card, the residence card. That procedure takes about 5 to 6 weeks. So that was about the immigration rules for Belgium. I will now give the word to Nadia from our UK practice to elaborate on the UK impact.
Thank you, Chris. So good morning, good afternoon, everybody. My name is Nadia Idris, and I'm a solicitor and senior manager with the UK immigration team, focusing very much on UK inbound immigration. So today, I just wanted to go through the impact of the end of free movement on EU nationals coming into the UK, so Belgian nationals coming into the UK. So what I wanted to do was just go through what the current position is and what the position will be post Brexit, which happens on the 31st of December of this year. So at the moment, the transition period is still in play, and therefore free movement for EU nationals still applies. This effectively means that any EU nationals who are travelling to the UK at the moment can continue to do so without being subject to any immigration control, without any type of work or immigration authorization. So they would come to the UK and present their original passports, and they'd be able to continue working, study, being self-sufficient, undertake any kind of visitor activities. Now, EU nationals who are in the UK at the moment and intend to stay in the UK beyond 31st of December 2020 must register under something called the EU settlement scheme, and that will effectively confirm their right to continue working in the UK as of next year. Now, there are two different statuses under the EU settlement scheme. There's a pre-settle status or the settled status, and you have to apply for that status by 30th of June 2021. Pre-settled status is granted to EU nationals who are currently in the UK and who have less than 5 years residence in the UK, and they intend to continue working post-Brexit. And settled status is granted to those EU nationals who've had more than 5 years residence in the UK, and it's akin to permanent residency. Those applications, despite needing to be submitted by 30th of June 2021, we are advising clients to submit those before the 31st of December. From a practical perspective, it just makes sense because it means they will have that right to work in the UK, or they'll be able to evidence that right to work in the UK and continue residing in the UK post the 1st of January. So from a practical perspective, if they intend to, for example, obtain any kind of public funds, apply for any type of school places for their children, gain access to healthcare services, rather than having to carry a multitude of documents with them, presenting their pre-settled status, settled status document will enable them to continue having access to those rights. Now, for employers, what you need to be thinking about at the moment is identifying your current EU national population and having that conversation with them around what they need to do before Brexit. So before the 31st of December, making sure they have the appropriate permission in place, making sure they're looking at the immigration status that they will need to retain post 1st of January, both for themselves and any dependents they have in the UK. What will happen from the 1st of January 2021 is a new immigration system will come into force, and that immigration system will apply to everybody. So it will be a global immigration system which doesn't differentiate between EU nationals and non-EU nationals. So right now, what employers should be doing is, if you're a UK-based employer who's bringing EU nationals into the UK or currently employing EU nationals, looking at something called your sponsor license. Now, in the UK, if you're intending to employ any non-EU nationals, you need to register with the Home Office and obtain something called a sponsor license. It's an online verification of your right to employ non-EU nationals in the UK. And what it does is it has specific compliance requirements attached to it. So what you would do is you'd be looking at your sponsor license, looking at what the expiry date is. It runs normally from a 4-year period. And that 4-year period runs from when you initially applied for your sponsor license, and making sure that you continue to meet any of your compliance obligations. You should consider undertaking an immigration health check, so looking at whether or not your policies and process are fit for purpose post-Brexit, looking at whether or not you have enough work authorizations under that sponsor license to continue employing individuals post 1st of January, when that system applies to all non-British and Irish nationals. If you don't have a sponsor license in the UK, that means as of 1st of January, if you are looking to employing anybody who's a EU national or non-EU national, you will not be able to do so unless you have that sponsor license in place. So any EU national who's coming to the UK from the 1st of January for the first time with the intention of working will require work authorization before they travel. That work authorization cannot be obtained unless an employer has a sponsor license in place. So really looking at what your recruitment needs are for the next couple of years, looking at whether or not you need to recruit from overseas, and undertake the appropriate due diligence and making sure that you are applying for a sponsor license as a matter of priority. Depending on which route you opt for, sponsor license applications can take up to 18 weeks to be considered, although priority services are available. So looking at your current population, identifying what system they will fall under, and identifying whether there is a need to get a sponsor license or renew an existing license will be imperative for employers. Now, what happens when the transition period ends? So in the UK, we have seen a new immigration system come into force. It will come into force fully on the 1st of January 2021. It's the biggest change to UK immigration history for the last 40 years. So once Brexit has happened, as of 11 p.m. on 31st of December 2020, all non-British nationals will be subject to exactly the same type of immigration permission if they intend to work in the UK. That new immigration system will partially come into force on the 1st of December for only non-EU nationals, and for your EU nationals, the system will become applicable from the 1st of January. So EU workers will effectively be deemed third country nationals if they are travelling to the UK for the first time to work from that date onwards. Therefore, they will need to obtain any type of work authorization and immigration permission prior to any travel being undertaken. So it's going to become really important to assess what that EU national will be undertaking what kind of activities they'll be undertaking in the UK to determine what type of immigration permission is going to be required. Now, one thing I would flag is Irish nationals are not going to be subject to the new immigration system, and that is simply because, notwithstanding they are EU nationals, under UK immigration law, they have a special status granted to them. So Irish nationals, as soon as they arrive in the UK, they are deemed to be settled, which means they are deemed permanent residents, and therefore they will not need to get any type of sponsorship or work authorization if they intend to work in the UK, even if it's post-Brexit. Now, if you are thinking about employing EU nationals in the UK from the 1st of January onwards, there's going to be two options available. If you are looking to sponsor them directly as an employer, which means that individual is tied to you for the duration of their employment, there'll be a skilled worker category, and there'll be an intra-company transfer route. So your skilled worker category is normally going to be applicable to those individuals who are going to be new hires or local hires to the business in the UK, and they intend to remain in the UK on a permanent basis. Skills thresholds will be applicable, as will salary requirements and qualification requirements. What's important to bear in mind is a skilled worker route will require satisfaction of the English language requirement for anybody who's applying under that particular route, even if they are EU nationals. The intra-company transfer route is again when you're transferring individuals from an overseas entity, overseas linked entity, to the UK entity for the purpose of undertaking work which is temporary. So it may be on a short-term assignment, it may be for cover. But if that individual is undertaking productive work, then intra-company transfer route may be a possibility. An important differentiator between the skilled worker and intra-company transfer route is that the intra-company transfer route does not lead to permanent residency. The skills threshold is a lot higher. So for the intra-company transfer route, you're looking at RQF level 6 requirement, whereas for the skilled worker, you're looking at requirement of RQF level 3. The salary thresholds are also different between the skilled worker and the intra-company transfer routes. So for the intra-company transfer route, you have to meet a minimum salary of which is over 41,000, whereas for the skilled worker, it's 25,600. But bearing in mind for both categories, not only do you have to meet the category salary threshold, there are also salary thresholds applicable to the type of role that the individual is undertaking. So in both instances, you're looking at a two-pronged test. You're looking at number one, do they meet the category salary threshold, and do they meet the minimum salary threshold for the role that they're going to be undertaking? And whichever is higher must be met in order to satisfy that salary threshold criteria. Ultimately, it will be a new points-based system, and as I said, you'll be awarded points for skills, salary, English language, and sponsorship. And ultimately, we will be looking at what type of role the individual is undertaking in the UK, because again, that determines whether or not that individual can be sponsored by the employer. There is a visa waiver in place for short stays, and this is where you have individuals who are coming to the UK to undertake business visitor activities. So that pre-assessment of activities for individuals is going to become really important, particularly where they're EU nationals and previously they may have been able to just hop on a plane, come to the UK, work in the UK, or undertake business visitor activities without being subject to any kind of control. Now, post-Brexit, the assessment of activities will become really important because the business visitor rules limit the type of activities that you can undertake in the UK. So there's permissible activities which are listed, and if you don't comply with the business visitor requirements, there are compliance obligations. Well, there are repercussions for both the employer and the individual, whereby that becomes really, really important to declare on any future immigration application. Permissible activities as a business visitor may include, for example, undertaking fact-finding, attending meetings, undertaking internal training. Productive work is not permissible as a visitor at all. So if you are coming to the UK as a visitor, it'll be important to ensure any activities are limited to those that are permissible within the business visitor guidelines. Payment cannot be received in the UK as a business visitor either. Now, one other point to mention is there is going to be a frontier worker permit, which will come into force on the 10th of December of this year. The frontier worker permit is going to be applicable to those individuals who are resident overseas but employed in the UK, so that either employed as workers or employed or self-employed. As long as they can evidence they are working in the UK, they may then qualify for that frontier worker permit which then needs to be applied for before the 1st of July 2021. The individual has to be a frontier worker before 31st of December if they're an EU national, and it will only be applicable to EU nationals. An important point to bear in mind with the frontier worker permit is it doesn't lead to UK permanent residency. For self-employed, it will only be granted for a period of 2 years, and for employed workers, it will only be for 5 years. Again, the full details in terms of what the application process will look like, what full criteria needs to be met, haven't yet been published, but we do know it's going to go live on the 10th of December of this year. So it's really important, again, to be looking at what type of individuals you have in traveling to the UK, what's the structure of the assignment, what exactly will they be undertaking, what are their long-term plans, are they intending to rise in the UK permanently on a project basis, to determine on what type of immigration category is going to be applicable. Thank you. So what's going to be really, really important is looking at an assessment of your employees, who's impacted by a Brexit and in what way are they impacted? How does that impact your key stakeholders, including your travellers and any of your recruiters, your recruitment teams, your project managers? How does your business function and who needs to be aware of what changes are coming into force? It's really going to be important to ensure you have the important documentation in place on post-transition, both from an immigration and social security perspective. It's really important to discuss that future recruitment strategy to make sure you're planning both from a budget perspective and from a compliance perspective in terms of what actions need to be undertaken. And it's looking at the lead times. So whereas at the moment you might have an EU national being able to travel to the UK, as I said, without having to satisfy any kind of pre-criteria or prerequisites, they can simply hop on a plane and come to the UK. Come the new system, any EU nationals travelling to the UK will be looking at lead times of approximately 4 to 6 weeks. So 4 to 6 weeks is an estimate of when individuals need to provide their documents, review of documents, and actually applying for any type of pre-authorization that they need before they travel. And the budget again needs to be looked at. So whereas at the moment to recruit an EU national, you're not looking at any immigration costs at all. Again, the settlement scheme is free. For an individual who you might be looking to recruit for a 3-year period from the 1st of January, just for the government fees themselves, you're looking at almost £6,000, excluding any type of professional fees that may be applicable. And again, it's going to be really important to manage any kind of negotiations that you might have on social security and the impact on contribution and benefit costs for new moves post-transition. Thank you.